Hello, and welcome to Law Talk. My name is John Celebrezzi, and I'm the co-founder of the Celebrezzi-Zangi Community Legal Education Project, as we call it, CZ-CLEP for short. Our organization provides continuing education about the judiciary and legislature to attorneys, judges, government officials, and the general public. As a career educator, I recognize early on how important legal matters are and how they impact our lives. I am the nephew of the late Anthony J. Celebrezzi, who was the popular 5-term mayor of Cleveland and a member of President Kennedy's cabinets. As a tribute to his lifetime commitment to the legal process, we dedicate this show. Our guest today is Ken Marco. Ken is the managing partner of the Medina law firm of Marco & Bailey. He's the youngest son of the firm's founder, Richard Marco. Ken did his undergraduate work in the area of criminal justice at the University of Akron, and later earned his Juris Doctorate from Cleveland Marshall School of Law. He's been practicing in Medina County for 19 years. Ken is also admitted to practice before the United States District Court, Northern District of Ohio. Albeit Marco and Bailey lawyers handle a wide variety of both civil and criminal matters. Ken specializes in the firm's probate matters. Welcome, Ken.
Thank you, John.
Well, thanks for coming. We're going to talk in a little bit, Ken, about probate, and albeit we've had a lot of lawyers and judges on the show, talked about a lot of other things. I think this is one of those areas of law that a lot of people don't know too much about. Would you agree, or?
Yeah, I think so. I think the majority of people that come into my office that have probate questions, first they come in, they might want to talk about, setting up wills or trusts or things that they've seen on TV. But a lot of times they're coming in because, somebody in their family died.
I see.
Whether it's their husband, their wife, or a family member. They come in and they really have no clue where to start.
Sure.
And a lot of that has to do with, the loss that they just had.
Sure. Ken, the word, we have to start somewhere, and to the lay person, frankly, I don't know if he knows what this means, but what does the word probate mean?
Well, usually in the context, if you're talking about the legal context, it's usually the process in which you, after somebody passes away, that somebody gathers a person's probate assets, keeps those assets safe, and eventually inventories and distributes those assets to the beneficiaries.
So it's kind of a general term, and it happens on the passing of somebody. When you say you're going to probate a will.
A probate a will, a probate estate. It's general. It's a legal term. I don't know if there's any specific definition for what probate is, but it's more of a way of distributing assets, handling a person's estate.
Here in the county, Ken, I've had a lot of the judges on, but I've never had Judge Lone on per se. But is he the judge that oversees probate matters at the court?
Yes, he oversees all the probate matters at the court. And probate can also, the probate court also handles other things besides administering people's estates. They also establish guardianships for either a minor or incompetent.
I see.
He also handles, if there is will contests or anything that has to do with the administration of an estate, marriage licenses. There's a lot of things that happen.
Sure.
In the probate court.
So probate is actually a division of the common pleas court?
Yes.
I see. And so he's a judge that you oftentimes practiced before.
Oftentimes you go in front of Judge Lone. Plus he has magistrates. It's a pretty broad area. It's a lot for one judge to take care of, especially in a county of our size.
Sure.
So that he has magistrates that also help him get you through the probate process.
Do you you mentioned guardianships. Do you personally do that type of work as well?
If a lot of times if the court needs to have somebody become a guardian for a person, either because of they've deemed to be incompetent, which is actually a legal term, just because somebody can't handle their affairs or is unable to handle their affairs, the court has to determine that they're not able to handle their affairs and will appoint a guardian that basically steps in the place of the person and can handle either their finances, and making sure the money goes where it's supposed to go, or even has to make personal decisions for that person. They actually step into that person's shoes and technically become that person.
Wow. So that's something you've been known to do in your professional life as well?
I've had a few guardianships. It's a very big responsibility.
I could see so. I mean, having taken care of my own parents in their later years, to step into somebody's shoes and make those type of decisions. But, well, very much appreciate that. So this is all part of the world of probate, of things you deal with. The word will, I mean, I think every day we throw that word out, do you have a will, or I'll leave you in my will, or something about a will. We see it on the television, but that too is actually a legal instrument, isn't it, Ken?
Yes, the statute requires certain things to be done inside a will, or certain requirements of how the will is signed in order to create the legal document that can be probated as the person's last document, really telling the world where they want their assets to go, and also who they want to take on the responsibility of gathering those assets and making sure that those assets go to where they want them to go.
So when you write a will, and you do write wills pretty often,
we write quite a few wills.
Yeah, I figured you do, as busy as that place normally is. But I guess you're trying to glean from the person while he's alive, and that's a pretty important document when he's gone, because he can't speak anymore, just exactly where his stuff and his assets and what happens. Is that correct?
Yeah, and it can get quite confusing. A lot of times I'll bring somebody will come in the first time, and we'll talk to them about where they want their assets to go. And I think what a lot of people don't realize is there's a lot of what ifs. Leave everything to your spouse. Well, what if she passes away first?
Right.
I want to leave everything to my children. Well, what happens if one of your children passes away before you do? And most people don't think that way.
Sure.
Most people expect that they will die before their children will die. Where do you want those assets to go? Do you want them to go to that person's spouse? Do you want them those assets to go to their children? Do you want those assets to go back to the remaining beneficiary? So there is a lot of what-if situations. So sometimes, we talk about it, tell people to write down what their assets are, where they want them to go. And a will can be as specific as somebody wants, or it can be fairly general, like I want all my assets to go to,
So it sounds like, Ken, I mean, here's where I think lawyers get the name, rightfully so, consular, of sitting down with somebody and calling these things to their attention, the what ifs, as you call them. And I guess it would then make perfect sense that if something as important as this, rather than go to your local office supply store, where sometimes they'll say you could buy one of these things pre-made, that probably won't get the job done as well as somebody sitting down with you. And
I think those documents do have their place for some people, but most of the time they don't go deep enough into what a person really wants, or makes a person think about where they want their assets to go. There's a lot of scenarios that that most people don't think about when they're drawing up their will.
Sure.
One thing is if their children pass away, or somebody passes away, if they want their children to get those shares, well, if those children are under 18 years of age, do they want somebody to be in charge of that money until that their grandchild becomes to be a certain age, and what age is that? Mm-hmm. And everybody's situation is different. I mean, if they have kids, you have children,
Sure.
Occasionally you'll have one child that's very responsible.
Yeah.
Another child that, if you put $100 in his pocket, he's spending 110.
Right.
So how do you protect your children after you're gone?
Yeah.
And to make sure that that they're taken care of too.
So when a prospective will client, if you will, comes through your door, sits down with you, there's a lot to talk about here before you ever pick up a pen to start to write this.
Yeah, I'd say usually the initial consultation could last, at least 45 minutes to an hour.
I see.
And one of the biggest things now too is the blending of families. A lot of times you have somebody come in and they have children from a previous marriage. They get married and they have children, or their spouse. Their new spouse has children. Well, how do you distribute those assets evenly amongst all the different children and to their surviving spouse while still protecting the rights of your own children?
Yeah, good point. Isn't it true, Ken, though, that actually most people don't have a will?
I get a lot of people that come in that are, later on in life, and 40s and 50s isn't later on in life, but that's usually a time when they've accumulated some assets, and they finally come in and says, we've been talking, and it's time that we
now it's time to have one.
Put together a will. Most people that come in, after somebody passes away, I think people now are becoming a little more sophisticated, and most of them do have a will, but I'm sure there's a good majority of people that have never thought about it, and it's not really the most pleasant thing in the world to think about.
But it sounds like a pretty important thing to have, though.
Oh, definitely.
I mean, it's going to make things a lot easier when the inevitable happens to all of us. When you have one, you've prepared it. What's the best? I wrote the question on it. What is the best place to keep your will? I mean, unfortunately, you won't be the person using it when the time comes. So what do you do with it?
Well, we offer a client, we actually have a fireproof safe in our office, and we will offer the client the option of keeping the original in our safe.
Oh, so you would have it, I mean, when the inevitable happens, assuming you're going to be the person that works through the probate process, the will's there.
Yeah, we have the original will. Plus, the problem can become is if somebody does take it home and they don't tell somebody that, oh, by the way, I put the will up in the attic behind the, behind some loose boards. If that person's passed away, obviously they can't tell anybody where their will is. Some people do have an area where they keep all their important documents, but they do need to tell somebody, where the will is at.
Kind of a housekeeping type question, but an important one, because a person was, shall I say, responsible enough, I guess that might be one way of saying it, but hired you, put this all together, tried to make sure everything was arranged for assets to go to the appropriate children, and if nobody knows where it's at, it's not going to do any good. So that's really does make sense to have it. Certainly you have your lawyer or some person who's going to be your administrator, which we'll talk about, or executor, know what's that. Ken, is there really, like you see on television, is there really a reading of the will?
I know of some lawyers that still do that will bring in the beneficiaries and actually read the will. The problem I've found with that is because we're in a society where people are so mobile, you might have some of the children living out of state.
Sure.
You might have them, down in Florida or out of the country. So I generally don't have a technical reading of the will. Usually, my first letter to them is sorry to hear about the passing of your father. I'm including with his, father or mother. I'm including with this document a copy of the will.
There's a copy of the will.
And so that they've received a copy of it that way.
Well, I've seen enough plays and movies where it's
very dramatic.
Very dramatic, but I guess it doesn't exactly work that way. But it's a good point. In all of our families now, we have people. Our world has gotten smaller. I mean, people live all over the place, and that might not be too proper.
I actually had a beneficiary of a will once that was a missionary, and he was a missionary in South America. So to get him documents, we actually had to send the documents to Florida. From Florida, they went by boat over to South America. They were loaded on a horse or a mule, taken to the village and delivered the documents there. Then they had to reverse the order back
to you
and come back to me. So to to ask him to come in
Yeah, it wouldn't be too practical.
to read the will. I don't think he was going to do
That's
that.
an interesting story, Ken. Ken, what's the difference between an executor and an administrator of a will?
An executor is usually the person named in the will. A part of a will is, besides the distribution of the assets and stuff, is naming a person that you want to handle the estate. Usually in a husband and a wife, the husband or wife will pick the other party out as the executor, and as a substitute will name somebody else. If somebody, and when you probate that will, you also ask that that person be named executor of the estate.
Okay.
An administrator usually is somebody, if somebody dies without a will, they make an application to administer the estate, and the court has to approve them. Usually an executor is pretty automatic. I mean, if it's named in a person's will, courts generally don't like to disrupt what a person wants to do in the will. An applicant has to be somebody that's related, generally related to the deceased person, and an administrator is not as free to do what they want. Usually in a will, they have broad range of powers. They don't have to apply to the court to sell real estate. They don't have to apply to the court to do certain other things. An administrator is more bound by the law as to what they can and can't do.
What happens, Ken, if you had a family that there was no, now I understand, I guess the executor, that was all predetermined and you wrote it into the will, and like I know in my case, my son will be my executor, but what if you got a couple of siblings and they both apply?
If they both apply, then normally the court would hold a hearing and determine who is best suited to administer the estate.
Could get a little acrimonious, couldn't it?
Well, sometimes it can. Everybody wants to believe that their children will get along after that they pass away, but sometimes it just doesn't happen.
I see.
And there are some children that are better suited to administer an estate than others. And it's just that the court will have to listen
Judge
to
has
what
got to
each
make
one
the
has to say, and the court, the magistrate, or whoever is doing the hearing has to make
the call.
They make the call who they believe is the best person to administer the estate.
I see. When you hear the term, and I know you hear it all the time, when somebody says we have to, or a lawyer says, or anybody says, when we have to open an estate, what does that mean?
A lot of probate work is form driven. To open the estate is where you start to gather that information and you put it on the court's forms, and it's basically telling the court, who the deceased person is, when they passed away, where they lived or where their domicile was, who the beneficiaries, either the natural beneficiaries would be like children, things like that, and who was named as beneficiary in the will itself. And also you have to, when you open up an estate, you have to give the court a rough idea of what the assets, or what the value of the assets are. When you open an estate, that it doesn't have to be a perfect number. That happens later on. You can say, we believe the estate is worth, $125,000.
Estimate.
It's kind of an estimate. When you're doing an inventory later is when you have to be more precise of what the estate. And that's generally when the will's probated or admitted to probate, and you open the estate. That's the beginning of the estate process generally.
Okay. This would be a job that is probably best suited for a lawyer to do?
I believe so. There are a lot of forms that you have to fill out, and most people think, oh, it's just a form, you just throw in a number, but that's just not the case. You have to determine, one, is it an estate asset? Does it belong in the estate? You have to figure out which form it goes into. There are certain things that you have to serve upon beneficiaries. There are certain things that you have to do, and the form is a general outline. But there's a lot more work involved than just filling out pieces of paper and giving them to the court. Plus, the court has timelines. You have to have the inventory done within a certain period of time.
So what happens if somebody well, lawyer or non-lawyer, if somebody misses, it blows the deadline, what happens?
Usually the court will issue a citation or a warning. They'll tell you your inventory was due on January 1st, you failed to do it. Please have it done within a certain amount of time. If you don't have it done within a certain amount of time, the court can actually order you into court and can remove that person as executor of the estate. Medina County is a little bit easier to get along with. I mean, it seems to be a court that's more willing to help you out.
Sure.
You get into a place like Cuyahoga County, I mean, they will remove you as executor of the estate if you mess up, and it might be due to because of the volume.
Sure, I'm sure it probably does. There's a huge volume there, but you make a good point. Is somebody who, I mean, is a non-lawyer. I mean, you're going through the loss of a loved one and whatnot. Would seem to me that the guidance that you would give your clients would be pretty important at that point.
Plus, you can't really go to anybody to ask questions. The law clerks that are at the probate court, they're very helpful, but they're not allowed to give legal advice.
Sure.
So if a non-lawyer goes in there with a form that's not correct, you know, if they start asking the clerk questions, the clerk's not allowed.
Sure.
To give advice as this is what you need to do, and I think with a lawyer, I mean, one, they should know how to do it if
Sure.
they're going to open the estate, and plus it makes the process a lot smoother. It makes it smoother for the beneficiaries. It also makes it smoother for the court.
Yeah, that's a good point. That's a real good point. When we all pass, I mean, nobody knows when that's going to happen. We're probably going to owe somebody money. I mean, if it's your credit card statements or your bill or whatever. Is there a mechanism? How do they? Let's say I was the creditor. Okay, in other words, in this hypothetical, one of my clients passed or whatever, and I felt I was owed several $1,000s, and you happen to be the attorney representing my client as a probate. What do I do? I mean, how am I going to get this money?
Well, that's also driven by statute too. There's statutes that are specific to making claims on an estate. When the estate's open, the creditor has a certain period of time to make a claim on the estate, and he has to do it in a specific manner. The claim would go to the executor or the executor's attorney. They'd make a determination whether they want to accept the claim, the debt, or they can reject the claim. If they reject the claim, then it can go to hearing where the actually the court can make the decision as to whether it's a valid claim or not.
I see.
If it is a valid claim, if there's funds available, then it needs to be paid out of the state assets.
That's interesting. So not everybody who felt they were owed money is going to be guaranteed a payment under this circumstance. Somebody's going to look at it and scrutinize it.
Well, someone's going to scrutinize it, or the creditor might miss it completely, that there's an estate open that the person passed away, or they might feel that it's not worthwhile to make a claim.
But certainly forever hold your peace after
a certain period of time. I mean, it seems to me the estates that I've opened, most of the time, I don't get a lot of claims against the estate.
Really?
Either one, if there's sufficient funds in the estate account, usually the executor will handle those payments as they come in.
I see. Okay. Ken, what does it mean when somebody dies intestate?
Intestate is generally that means that they die without a will.
Well, if that happened, if you died without a will, how would anybody know where your stuff's going to go?
Because the state thought of that too. The probate court in the state generally wants to make sure that money gets to where it's supposed to go, or a person's assets where it's supposed to go.
Okay.
And generally people will distribute their assets in the same fashion. One to a surviving spouse, and two to the children or the grandchildren.
Yeah, makes sense.
So the descent, intestate succession or descent distribution follows a normal pattern. I mean, obviously first, taxes get paid if
Sure.
there's any taxes that are owed, or estate taxes. Most people do basically the same type of thing with their assets. So if you die without a will, the state will generally tell you that this is the normal descent distribution of assets.
I see. So it's the law. I mean, there's a statute that will step in if the deceased doesn't have a will.
They'll say, you didn't make a will, this is where we believe the money should go, and it'll follow a certain pattern.
But like any other law, though, Ken, it's still going to be subject to interpretation by a judge somewhere.
It can be. If there's a belief that, one, you could have beneficiaries that come out and say, my uncle wanted me to have these things,
Sure.
or I was told, or I have a piece of paper where he told me that he was going to give me his car or something. I mean, it can cause problems if there isn't a document in place.
Right. Well, we're coming to the end, but I do want to ask you this one question, and it could probably be a show unto itself. But what's a will contest?
A will contest usually comes about if there's a discrepancy in the will, or if the will wasn't done properly.
So we're all going to court? In other words, if I say I felt I have something coming and I'm told I'm not going to get it, I go hire a lawyer?
You can hire a lawyer. I mean, especially if there's competing wills. And Dad draws out a will in 2005. He passes away this year. The person that has the will from 2005 admits it to probate. Another beneficiary steps forward and says, "Oh no, that's not the real will.
Oh, okay. So
I have the real will."
I have the real will. So now we got two wills out there, and the judge is going to have to decide which is the good one?
Generally, the latest will replaces the earlier will.
I see.
But then there can be questions like, was Dad under undue influence
Sure.
when he signed this will? And that can happen if will number 2 seems to be out of character with Dad.
Sure.
Will
Sure.
number 1, especially if Dad, is the last one remaining, where he's generally given all the money to his 3 children equally. All of a sudden, will 2 comes along, disinherits 2 of the children, gives the majority of the assets to the 1 child. There's a question as to whether Dad was unduly influenced. Sure. You can do whatever you want in your will. If you want to disinherit children, that's your business. When people come in, if they want to do things like that, that is their business. But the question becomes whether Dad was pressured into it. And as parents get older, I mean, sometimes there could be some physical
Sure.
or mental
Sure.
ailments that could
Right
cause
Yeah.
some problems.
Well, Ken, I'd certainly like to thank you for being our guest on this episode of Law Talk. To view this episode, go to www.czclep.org. I am John Celebrezzi, and I thank you for tuning in to Law Talk.
To keep up on Medina County and other legal issues, go to www.czcourtreporter.com, a function of the Celebrezzi-Zangi Community Legal Education Project. At CZ we're devoted to the education of today's legal issues. Fueled by the public's keen interest in our legal system and current events, CZ is dedicated to the educational venues aimed at enhancing the understanding by all citizens. For a complete listing of dates and times for this telecast, tune in to WCTV Channel 15 or log on to wadsworthcity.com and follow the links to WCTV.
I'm John Celebrezzi. Please join me in getting a better understanding of the law.